Tenemos dos panelistas, quienes son David Hill, de Finnegan, Henderson, Farabaud, Garrett and Danner, LLP, y Alan Casper, de Sugrue Mion, PLLC. Nuestro panelista es Danny Huntington, de Rodwell, Fig, Ernst and Manbeck, PC. Voy a presentar al moderador y luego él se encargará de presentar a los panelistas. Danny es socio de Rodwell, Fig, Ernst and Manbeck, PC en Washington, D.C. Está involucrado en todas las fases de la ley de propiedad intelectual, incluyendo Estados Unidos y tramitación de patentes extranjeras, los litigios tribunales federales y estatales, la concesión de licencias, procedimientos de la Comisión de Comercio Internacional de los Estados Unidos y el asesoramiento de clientes en general. Tiene una amplia experiencia en patentes con especial énfasis en biotecnología y productos farmacéuticos. Dani.
Buenos días a todos. Quiero empezar dando las gracias a CIPI por haberme invitado a moderar esta sesión que trata el concepto cambiante de la ley de patentes a los Estados Unidos. Tengo el placer de tener como nosotros a mis buenos amigos Alan Casper y David Hill. La mayoría de ustedes sin duda los han escuchado hablar en las reuniones anteriores de CIPI y otros de propiedad intelectual. Voy a presentarlos brevemente a cada uno de ellos antes de que hablen. Sin embargo, quiero hacer una breve introducción del tema antes de que ellos comiencen. El título de esta sesión se refiere a un péndulo, que es una metáfora particularmente apropiada para describir lo que ha sucedido en los Estados Unidos durante nuestras carreras. Nosotros entramos en la práctica de nuestras profesiones en la década del 70, cuando las patentes no eran muy importantes. Sin embargo, como Alan explicará, a partir de la década del 80, las patentes se convirtieron cada vez más importantes. Y como era de esperar, la innovación también aumentó al mismo tiempo. Sin embargo, como en casi todas las cosas de la vida, no se puede hacer un uso excesivo de una cosa buena. Y eso es lo que sucedió en la ley de patentes, especialmente en ámbito de las patentes de métodos comerciales. El intento de que algunas personas se refieran como trolls de patentes para demandar a cualquiera de las grandes empresas o a muchas pequeñas empresas se tradujo en un impulso para contenerlas. Y para la mayoría de las grandes empresas, las patentes no son importantes porque tienen poder en el mercado. Las patentes son en realidad más importantes para las pequeñas y medianas empresas como una forma de competir. El resultado de estos excesos ha sido un impulso para cambiar las leyes y decisiones de las patentes por las tribunales, incluyendo especialmente la Corte Suprema, de debilitar a las patentes o las hacen invalidas y inaplicables. Desafortunadamente, los cambios realizados han afectado no solo a las patentes de métodos comerciales, sino también a todas las patentes. En el acuerdo sobre las TRIPS, los Estados Unidos insistieron en una disposición que requiere que todos los países miembros hagan que las patentes estén disponibles para todos los inventos, sean de productos o de procedimientos en todos los campos de la tecnología sin discriminación, sujeto a las pruebas normales de innovación, actividad inventiva y aplicación industrial. Lo que esto significa es que a pesar de que ahora está claro que las patentes en diferentes áreas de la tecnología son más o menos importantes, las mismas reglas se aplican a todas ellas. Así, por ejemplo, ahora estamos recibiendo rechazos de reclamos a las solicitadas biotecnología cuyos inventos podrían haberse hecho mentalmente o con un lápiz y un papel. Además, los nuevos procedimientos para enfrentar temas relacionados con las patentes en la Oficina de Patentes en los Estados Unidos, en lugar de los tribunales, han dado lugar a un sistema en el que las patentes son concedidas por una parte de la Oficina de Patentes y eliminadas por otra. Voy a proporcionar alguna información adicional sobre estos nuevos procedimientos después de que Alan y Dave hablen. Ahora me gustaría presentar brevemente a Alan Casper. Él es socio de Suprema en Washington, D.C. La práctica de Alan incluye de patentes nacionales y internacionales. Él representa a clientes en litigios, emite opiniones sobre la patentabilidad, validez y la violación y proporciona asesoramiento sobre asuntos relacionados con la concesión de licencias, protección de los derechos de propiedad, contratación y control de las exportaciones, asesora a clientes que están relacionados con los campos de electricidad, semiconductores, redes, software basados en computadoras y tecnologías mecánicas y proporciona asesoramiento para inventos en el ámbito de las patentes de métodos comerciales. Alan es coautor de un trato legal importante que ofrece un análisis exhaustivo y orientación sobre la America Invents Act y el futuro de propiedad intelectual basado en iniciativas de armonizaciones actuales a nivel mundial que será publicado en enero por el BNA. Alan, the floor is yours.
Thank you, Danny. And do we have the slides? Yeah, there they are. Thank you very much. So this is really a very important presentation because it's taking a look at the past to give us some idea as to what might happen in the future. In part one, which I'll talk about, there will be a presentation on the historical perspectives of the U.S. patent system and 4 very important periods that, consistent with our theme, show a swing back and forth of the attitude of the courts and the Congress and the Patent Office towards intellectual property and in particular patents. Dave will follow up excuse me, with a presentation on three very important areas that have been addressed by the courts as well as by the Congress. And then finally, we'll have, with time remaining, a roundtable discussion about where things are going in the United States and, in fact, globally. As to the historical perspectives, just to give you a very sort of quick overview, in the United States, and I'm sure this is true of many countries who are represented here in the audience, we have a three-part system of governance. There is, of course, the Congress, and then there's an executive that implements laws, and finally we have a judicial system that interprets those laws. That certainly is true in the United States as well. Most importantly, though, in the United States Constitution, which sets up these three branches, we also have a provision that deals specifically with patents. And the Congress, as it says, shall have the power to promote progress of science and the useful arts by securing for limited times, limited periods, to inventors the exclusive right to their discoveries. So from this very important passage, we see all of the activity that has resulted in this pendulum swing back and forth over the past 60 years, which I'll be talking about. So it starts, as I call it, the modern U.S. patent system with an act in 1952, a long, long time ago, perhaps before many of you were even born. I was born at that time, but in that particular act, there were some key features that dealt with three topics that I'll be focusing on in showing how this pendulum swing has actually affected U.S. law. The first is patentable subject matter, and in the law, it established Section 101, which basically said that anything under the sun made by man would be patentable. Very, very broad sweeping statement. It also talked about patentability and the three fundamental criteria for patentability: the invention having to be novel, having to be unobvious, and also having to meet certain criteria for description and clear claiming. And finally, the Act talked about enforcement. It was very comprehensive and dealt with the types of enforcement that can be held for direct infringement and indirect infringement. It actually established the criteria for those two categories. It also talked about the presumption of validity for patents, and also gave the guidelines for enforcement, that is, for injunctions as well as for damages. And in the damages case, specifically stating that the minimum damage should be a reasonable royalty. Well, we found that in the period of 30 years after that law was passed, and perhaps it's because the law was new and perhaps other factors affected it, the economy, maybe even communication capability, we found that in fact there was an anti-patent sentiment that was developing in the United States. And the reason for that really came from the fact that there was very little patent litigation at that time. And if there was litigation, we didn't have what we now have today, is a focus on jury trials. Instead, almost all the patent litigation was held before courts. The appeals were before, from those decisions of the courts, were before regional courts of appeals. And as a result, we found that there were very different interpretations of the patent law, depending on whether you sued in the west of the United States or on the east coast of the United States or the south. And so there was often forum shopping, finding the right jurisdiction to sue in, because you knew that that particular court of appeals was going to be favorable or unfavorable to the patentee. We also saw that in the Supreme Court, there were decisions that were somewhat ambiguous, but I think in large part sort of anti-patent. We had decisions in the software area, or the statutory subject matter area, Gottschalk and Parker v. Fluke, which held that certain inventions were unpatentable. We also had patentability decisions dealing with the standard for obviousness, the Graham versus John Deere standard, making it an objective standard rather than something that dealt with flash of genius, for example. And finally, we also saw the Supreme Court taking a very hard stand on the scope of enforcement, where it found that if you had all the parts assembled in the United States and shipped them to another country to have them assembled, that was not an infringement of a U.S. patent. So these sort of showed this anti-sentiment attitude by the courts. The U.S. PTO also was sort of mired in this backwoods or backcountry approach to patents. Prosecution was long and difficult. It was fairly expensive at that time to get a patent, and in fact, patents were not that enforceable. So you didn't have a lot of people seeking patents at the time. And the U.S. Congress was sort of asleep at the switch because it really didn't take any action during that 30-year period. Perhaps the only thing of significance is the passage of the PCT in the 1970s. But then, as we move forward, we find the second period I'll talk about, the 20-year period from 1980 to 2000, was indeed a pendulum swing in just the opposite direction, where we found that there was a very pro-patent attitude in the courts, in the Congress, as well as in the Patent Office. In the courts, first of all, the significant event that took place was in 1982 with the formation of the Federal Circuit based upon an act of Congress. The idea was to have a single court in the entire United States that heard all patent appeals. And it was significant because this was intended to provide consistency among all the decisions and interpretations of the patent law, and indeed, that's exactly what happened. Following on the implementation of the court and many of its decisions, we suddenly found that people found patents to be a very valuable asset. You also had trials by jury. You had the juries enforcing patents much more frequently. And so the number of applications that were being filed in the United States dramatically increased. And the Supreme Court itself also had a number of decisions that were very much pro-patent. We had, again, in the statutory subject matter area, the Diamond v. Chakrabarty and the Diamond v. Deere cases, both of which found subject matter to be patentable in the natural sciences as well as the algorithm area. We found Warner-Jenkinson, a case that dealt with patentability. The obviousness standard was made much clearer, and so much more predictability and certainty was given to the patent law. And we had the Markman case, which took the decision about claim interpretation away from the fact finders, away from the jury, and put it in the hands of the judges. So again, you'd have more consistency rather than this uncertainty that you found when you had jury trials. With regard to the PTO, prosecution became more compact. The allowance rate rose dramatically and peaked at a level well above 70%. So people were getting their patents, were enforcing their patents, and we also found that in the Congress, there were a number of additional improvements that were made to the U.S. patent law. Having publication at 18 months, for example, the overturn of that Deep South case by the Supreme Court, the U.S. Congress passed a law that said, indeed, if you have the parts made in the United States and you assemble them abroad, that is an infringement of the U.S. patent law. And so we see that overall, the swing in that period of time of 20 years was really very, very much pro-patent. But then moving on to the last 10-year period, 2000 to 2011, the pendulum goes the opposite way again. And we see that a number of Federal Circuit decisions were quite anti-patent. We found that patent litigation increased and in fact was considered to be quite unfavorable because we had a rise in non-patent patent entities, NPEs, that were filing litigation, the troll litigation that became a very great concern in the United States, particularly for the IT industry. And we also saw that patent marking claims increased. That is, if you mismarked a product with a patent number, either because the patent had expired or because simply the patent didn't cover that particular product, there was a basis for litigation. And in fact, the damages that were resulting from those suits, and they were brought by non-involved parties, just simply by groups of lawyers that were trying to make some money, it ended up becoming a huge problem in the United States. In the Supreme Court, we also saw that there were some decisions that were quite anti-patent. In the statutory subject matter area, the Bilski versus Kapos case very strictly construed what was going to be protectable under the US patent law. KSR versus Teleflex, here a decision that dealt with obviousness, and in that case, it was made much more easy to prove the existence of obviousness and therefore the invalidity of a patent because of the standards set by the Supreme Court. The Festo case was a case that ended up restricting the scope of the doctrine of equivalence. So therefore, the scope of protection that was given to patents, both by literal infringement as well as doctrine of equivalence infringement, was significantly narrowed. And finally, the eBay versus Merck Exchange case was a case that ended up tightening the requirements for an injunction. Under the Federal Circuit rules prior to that case, there was a presumption that there was irreparable harm caused to the patent holder if the patent holder could prove validity and could prove infringement. So that would immediately give you the basis for irreparable harm and therefore a permanent injunction. And the Supreme Court said, no, that's not really the correct rule. We need to go back to basics and look at what the fundamental requirements are for any injunction and apply those to whatever case is being heard. And so we suddenly saw that in the courts, there was again this constriction that was made on the rights that were being protected under the patent law. In the USPTO, there was a very famous proposal made of restricting the number of claims and restricting the number of continuations. This was called a claims and continuations proposal. It was the basis, in fact, for a litigation against the US Patent Office, and an injunction was issued against the Patent Office against them implementing this particular proposal. The Patent Office really trying to restrict, be anti-patent in its policies. And we saw that the allowance rate in the Patent Office in that 10-year period dropped down to about 40% because the Patent Office implemented what they called a second pair of eyes, another set looking at whether or not the original decision by the examiner was correct. So that and the activity in the Congress, Congress trying to pass a patent reform bill in the period of 2005 to 2010, again, failing largely because of the anti-patent attitude that had occurred. And a major stumbling block in that particular period was the fact that the IT industry was concerned about the troll problem and about the huge damage awards that were being given. And so the IT industry was saying, we want to really reduce the influence of patents. We want to minimize their strength, minimize their importance. On the other hand, you had the pharmaceutical industry saying, no, we want to have very strong patents because this is key to protecting our markets. So this conflict between these two industries really stopped any progress being made in the search for having a new patent law in the United States. In this period of time, we also saw that the Supreme Court began to take a great deal of interest in what was actually happening in the Federal Circuit. In the past, there was a Supreme Court case in a patent case, a Supreme Court hearing in a patent case, perhaps once every 5 years or so. But in this period of time we're talking about now, this 2010 to 2011, I'm sorry, 2005 to 2000 to 2011, we suddenly saw that the Supreme Court became very, very interested in the decisions of the Federal Circuit and began to look at them very carefully. And petitions for certiorari were granted to the point that there were, on average, about 4 or 5 Supreme Court cases heard every year in the patent area. Some of these dealt with patentable subject matter, where the Supreme Court attacked the CAFC decisions on patentable subject matter, dealing with a machine or transformation test, and rejected that test as being an important test for determining patentable subject matter. As to obviousness, the CAFC teaching suggestion and motivation test was also rejected by the Supreme Court, saying that this is one test, but it is not the exclusive test. As to enforcement, again, I talked about injunctions and how the Supreme Court overturned the Federal Circuit decision in E.UA. And finally, as to enforcement, the CAFC ruling that amendments made during prosecution presented a prosecution history estoppel. The absolute rule of the Supreme Court of the Federal Circuit was rejected by the Supreme Court. In this period of 2011 to 2015, we now have a question as to whether or not we do have an anti-patent or a pro-patent period. And I would say that the jury is still out with this regard. In the courts, for example, we see the courts have decisions made to restrict damages. And in fact, because they restricted damages, this allowed the AIA to be passed in 2011. And that law itself made some significant changes to U.S. law that could be viewed as being somewhat anti-patent. Patent litigation increased. NPE litigation continued to increase, and indeed is the basis that increases the basis for further legislative proposals before the Congress that are currently pending today. And the number of cases before the Supreme Court, again, increased to the point where we have 4 to 5 per year at this point in time. The cases I wanted to mention just briefly that dealt with damages, and in fact, because the courts dealt with this issue of damages, it allowed this conflict between the IT industry and the biotech industry, biotech pharma industry, to be resolved. And the courts themselves, rather than a Congress, solved the problem by having these 3 decisions that dealt with damages and eliminated some of the very positive rules or very pro-patent rules that gave large damage awards and now caused those awards to be restricted. The patent law changes were blocked because IT wanted to have strong anti-damage provisions in the patent law, and as I said, the biotech industry and the pharma industry didn't want to have those. These decisions by the courts took that whole issue off the table, and as a result, the Congress was able to pass the AIA in 2011. That's the good news. The law was passed. The bad news for patentees is that there are many anti-patent provisions in the law. So for example, while we do have first to file, some will say that that is actually anti-patent because the first to invent was actually more pro-patent for the party who was actually the first inventor. Here you now have a rush to the patent office to see who gets the patent first. Prior art was broadened because the Hilmer doctrine was eliminated, so therefore the scope of protection, again, is much more limited. The grace period was narrowed, limited only to what the actual inventor had done. The post-issuance review proceedings were established, and Danny will talk about that a little bit later. Prior user rights were expanded, and multiple defendant litigation was rejected. So all of these things brought the pendulum back to the anti-patent side. We do have new legislation that's pending now that in fact will restrict it even more. Fee shifting, for example, loser pays is a big issue right now and largely arising because of the anti-troll sentiment in the United States and in the Congress, and the real party and interest having to be identified again as a result of that anti-troll sentiment. We do also have expansions in the trade secret area and the possible litigation to provide additional protection under Section 101, which we'll talk about a little bit later. As to the USPTO, we see that there was a rise in what they call the death squads for patents in post-grant review. And I won't talk about that much more here, but Danny will cover that in his presentation. USPTO appeals, huge backlog. Right now, 25,000, maybe 23 to 25,000 appeals remain pending, and they're only able to handle about 2,000 or 3,000 per year. So you can see this backlog will remain for quite some time. This is certainly an anti-patent event that has occurred. And extended prosecution also has become a problem. Multiple RCEs still being filed, and again, raising the costs of getting patents for applicants. There are a number of recent Supreme Court decisions, and Dave's going to talk about some of these. these decisions, again, constricting the kind of protection that's being given to patentees. The Alice case, which Dave will talk about, patentability, the Nautilus versus BioSig case, which was a rejection of the standard, a very strict standard that was applied by the Federal Circuit, and the Supreme Court now saying, no, in fact, you have to have a much narrower standard and one that is based upon, a broader standard, one that is based upon the reasonable interpretation of a claim rather than the very strict standard, insolubly ambiguous, that was applied by the Federal Circuit. And finally, as to enforcement, in the Como versus Cisco case, the Supreme Court rejected the principle that you could use a validity or invalidity opinion as a defense against an indirect infringement claim. The court said, we're talking about apples and oranges here. You cannot use a validity attack to show that you did not have an indirect infringement, which requires a knowledge or a scienter element. You can't use a validity or non-invalidity opinion to say that you didn't have the scienter because this is an infringement issue. You can only use a non-infringement decision or opinion as that defense. Another couple of cases, the Eon Corporation versus AT&T Mobile case, that to satisfy statutory requirements of Section 112, computer-based inventions must disclose the algorithm. So here again, raising the bar as to what actually has to be disclosed, otherwise the patent would be unenforceable. And as to patentability, the Williamson versus Citrix case very severely restricted the way that means plus function claims would be interpreted. The old rule was that if you didn't have the word means in the claim, that there was a presumption that it was not a means plus function limitation, therefore not subject to a very narrow interpretation. The court said, no, that's not the case at all. We have to have a much broader standard, and so other words, the means or the unit or the element would all be considered broad because they don't have structure and they're primarily the prelude to a functional limitation in a claim. So the conclusions are that in the past, of course, over the past 60 years that we've just taken a quick look at, there have been dramatic swings, both back and forth, pro-patent and anti-patent. But in the future, what's going to happen? Well, I think my own personal opinion is that the courts will continue to be rather restrictive about patent rights. But I think we're going to find that the legislation, the Congress will pass legislation that will help to improve at least the scope of protection that's given to inventions. My expectation would be that we will have legislation sometime in the next 5 years, it'll take that long, to broaden the category of statutory subject matter and overturn some of the Supreme Court decisions, just like the Congress did when it came to the Deep South case. And I think we're also going to find that there'll be the restrictions on litigation are also going to be a very significant factor, which perhaps might be considered anti-patent, because you will have to have much stronger pleadings, much more clear and more definite pleadings when you're going into court claiming patent infringement. You'll have to be able to identify what the products actually are and how the products are infringed by or are infringing the claims by very detailed pleadings in court. But I think at the end of the day, this is perhaps best for the system overall, so that there's going to be more confidence in what we have in our U.S. patent system. Thank you very much.
También contamos con la presencia de David Hill. Él es consejero mayor de Finnegan, Henderson, Faribault, Garrett and Dunner en Washington, D.C. Dave tiene especial experiencia en las artes mecánicas y eléctricas y también ha participado ampliamente en una gran gama de asuntos relacionados con marcas Él ha dado muchas opiniones sobre cuestiones jurídicas y técnicas complejas. Su experiencia en litigios incluye numerosos juicios por infracciones de patentes y apelaciones en los tribunales estatales y federales. También ha participado como testigo experto, árbitro y ha actuado como mediador. Dave, the floor is yours.
Thank you very much, Danny, and thank you to ASIPI for inviting me to speak today. I was actually a stand-in for a previous speaker who is testifying today before the U.S. Congress, one of the committees, on the new proposed trade secret law. That's Jim Pooley. As Alan said, I'm going to talk about three specific areas that have presented issues currently that are problematic for U.S. Applicants for patents, and also some that are, I think, projected areas for the Supreme Court may be considering in the future. This is just a quick list of some of the things Alan already covered. We can see that generally patent scope has been reduced over the past 5 to 10 years, limiting what constitutes infringement. The decisions of the Supreme Court and the Federal Circuit in both cases have somewhat limited what is infringement. Damages have been getting smaller, as Alan mentioned, and generally the Supreme Court has been trying to eliminate differences, I think, between patent law and some other areas of law in how the courts look at things. The E.UA case is a good example that Alan spoke about. Then Alan mentioned the PTAB proceedings on the rise, and actually ITC 337 cases, unfair import cases, have been reducing gradually. So I think generally there's been a lot more attention paid in the press in the United States to patents. Alan mentioned the Bilski case, and I'm going to start with a discussion of Section 101 in particular, because that's really one of the areas that's presenting the most problems for patent attorneys in the United States and elsewhere on how to write claims that we think can be patentable. And Bilski, of course, was a very broad set of claims that covered a business method. It was actually a method for hedging risk in a commodity trade. So it didn't have structure of any sort in the claim. And the Supreme Court, as Alan mentioned, found that that was just an abstract idea, that the claims covered only an abstract idea. At the same time, they recognized the test that the Federal Circuit had established, what we call the transformation test, and said that's one test, it's not the only test. So Bilski, at least one thing good came from Bilski, and that was that the court did not totally eliminate business method patents. They didn't say that business method patents couldn't be patentable subject matter. Another case in 2012 went to the Supreme Court. That was Mayo versus Prometheus. And in this case, the court dealt with something that was a method for diagnosing a particular type of therapeutic treatment. What they found was that this was just a naturally occurring result and therefore was not patentable subject matter. And finally, the 2013 case of AMP versus Myriad created a very solid rule, I think now, that a naturally occurring isolated DNA is not patent eligible in the United States. I think that same rationale has been now adopted in a few other countries. Of course, that changed the law in the United States. The US Patent Office had been issuing patents for a long time on isolated DNA claims. So there are a bunch of patents out there that are invalid based on this Supreme Court decision. The most recent case that I think created a lot of uncertainty is the Alice Corp versus CLS Bank case in 2014 at the Supreme Court. It was one of the most contentious areas of law under 101, and that has to do with whether or not a particular invention that relates to simply an abstract idea can be patented. The Supreme Court had already addressed this issue in numerous cases over the years, as Alan mentioned, in the Chakrabarty and Benson and Fluke cases. And usually those cases came out in a negative way, not all of them, but in most cases the patent owner lost. In the most recent decision, the Federal Circuit in this Alice case was very split. They had a whole bunch of different opinions. The judges were not in agreement, and they had an en banc decision in the Alice case, but they eventually found that the invention was patentable. And it went to the Supreme Court, and the Supreme Court reversed that decision. The issue was whether the claims to a computer-implemented invention, including claims to systems, machines, processes, and items of manufacture, that comes right from our statute, are directed to patent-eligible subject matter. There are three types of claims in the Alice case. There's methods of exchanging obligations between parties, systems for carrying out a method, and computer-readable media containing a program code for directing an exchange of obligations. But the basic idea of this Alice patent related to computerized schemes for mitigating settlement risks. So there was nothing really structural in these claims either. They were methods of doing business, essentially. Now, I know you can't read this claim, but I put it in here anyway. This gives you an idea of the basic claim at issue in the Alice case. It's a representative one of the claims. The holding in Alice by the Supreme Court was that because the claims were drawn to patent-ineligible abstract ideas, they're not patent eligible. So what the court did was followed a two-step test, which they had established in the Mayo case. And the two-step test requires that you look at first whether or not there is, a patent-eligible item in the claim. And I'll show you what the Patent Office developed as a two-step test in their subsequent guidelines. Is the claim to a process, machine, manufacture, or composition of matter? That's from the statute. If the answer is no, of course, it's not eligible. If the answer is yes, you go to the second step. Is the claim directed to a law of nature, a natural phenomenon, or an abstract idea? Those are the three main judicial exceptions that our Supreme Court has developed. If the answer is yes, then you go to a third step to determine whether the claim recites additional elements amounting to significantly more than these three judicial exceptions. If the answer is no, then you don't have to worry, it is patent eligible. Now, what happened as a result of the Alice case is that the Patent Office in December of 2014 issued interim guidance for examiners on how to examine patent applications under Section 101. And here's a list of some of the examples that were in the interim guidance that the Patent Office put forth. And these came from other cases that had already been decided. Examples of what is abstract idea: creating a contract, using advertising as an exchange or currency, processing information through a clearinghouse, comparing new and stored information, using rules to identify options, using categories to organize and store and transmit information, and so on. So obviously, all of these are situations where there's very little structure in the claim itself of the patent application. As far as natural laws and other phenomenon, they listed isolated DNA, which of course I've already mentioned, but also correlations stemming from how a certain compound is metabolized in the body, which is the invention in Mayo, electromagnetism for transmitting signals, which is a very, very old US case involving Morse, the inventor Morse, and chemical principles of union between fatty elements and water, another very, very old US case. Well, what happened about these guidelines is that they didn't really provide the working attorney with any meaningful information on how to write a claim. They didn't give us specifics. This is a table that the Patent Office included in those guidelines. I know it's difficult to read, but some examples they gave of what is significantly more and what is not significantly more under the two-step test. The result of that was a lot of criticism. The patent bar especially submitted many, many comments to the Patent Office on those interim guidelines. As a result, they issued a second set of such guidelines, or a supplemental set of guidelines, in July of this year, giving more examples and giving us some example claims even. But the bottom line is it's still very, very difficult for us to know what is abstract based on these cases. The Supreme Court hasn't given us any guidance on what is abstract and what is not abstract. The Patent Office has tried to do that, but it's still a very, very difficult thing for us. This case is a very interesting one. When we thought all was lost, the Federal Circuit decided this DDR Holdings case not too long ago, and this case involved a system for generating a web page, which you would think might be subject to the Alice problem. It might be considered to be an abstract claim. In fact, the Federal Circuit used the two-step test and found that this claim was patentable. So this is a step back in the right direction as far as patent owners are concerned, and we hope there will be more good decisions that will interpret the claims this way. On step one, they said, yes, it's directed to a machine. And then step 2A, they said, it's not directed to an abstract idea because the claim solution is rooted in the computer technology that overcomes a problem in the realm of computer networks. So that basically eliminated the issue of whether it's an abstract idea. So where do we stand on these issues? If you're a patentee or a patent applicant, you need to characterize, I think, the claims in a more specific way, not very generally, such as the Bilski case claims. You need to focus on a special purpose device. If you include a computer in the claims, it can't be just a general purpose computer. You have to have a more specific definition of that device. You need to identify specific applications and the claim language supporting those applications. Identify specific hardware, if you can, in the claims. And demonstrate that the claimed features cannot be done in one's mind or by paper and pencil. That's important. The Supreme Court often says things about, oh, this could be done by a paper and pencil, or you can do this mentally, mental steps. If that's the case, you need to convince the trier of fact or the patent office that that is not what you're doing. You need to explain why the invention is not fundamental or a building block or a basic tool. So it's much narrower claim perhaps than you want, but still you have a chance to write a claim that's going to satisfy the patentable subject matter standard. And you should emphasize the technological advancements or solutions. The invention, for example, in the DDR case, is in the computer realm, but the solution was directed to a specific problem and was able to solve that problem. Thank you. From the standpoint of the accused infringer, you need to characterize the claims generally. The more general you can characterize them, the more chance you'll be able to prove that it's an abstract idea. Present why the claimed invention is merely an implementation of what was done in somebody's mind, as I said. If you can do that and you're the accused infringer, you have a good chance of prevailing on the issue of whether it's an abstract idea. And argue that it's a fundamental building block, that everybody needs to use it. It's not something you invented specifically. And so on. Focus on the general purpose nature of the device, not its specific nature. This is what you should do if you're accused of infringing one of these claims. Now, the second area I want to talk about briefly is standard essential patents. A patent that must be practiced to use part of a technical standard set by a standard-setting organization is what we call a standard essential patent. And these are sometimes mandatory parts or optional parts, but standard-setting organizations like ETSI or ITU or ANSI will have these kinds of standard-setting rules. And basically, if you're a patent owner and you wish to belong to a standard-setting organization, you're going to have to disclose any patent that you have that might be essential to the practice of that standard. So when you do that, you enter into a contract with the standard-setting organization. The contracts vary by organization, but they might require that you license that patent royalty-free, or more commonly that you license it on reasonable and non-discriminatory terms, or sometimes what we call fair, reasonable, and non-discriminatory terms, FRAND terms. Or you can, in some organizations, not give any licensing commitment. This case I'm going to mention briefly, the Apple versus Motorola case, dealt with standard setting or standard essential patents. And in this case, the Federal Circuit clarified that even when patents are subject to FRAND obligations, injunctions can still be appropriate in some cases, as long as you follow the appropriate Supreme Court guidance of the E.UA case. You could still get an injunction in a case where you have agreed to license that patent to others in the standard setting organization, as long as you can prove the elements of E.UA. As I said, a FRAND assurance is really a contract. you enter into a contract with the standard-setting organization, and if you fail to offer licenses on FRAND terms, you can be accused of breaching that contract. Okay, I'm going to skip over to the last item that I have today, which is patent exhaustion. In the United States, a patent is exhausted when an unrestricted sale takes place of the patented product. And that's been the law in the United States for since the 1800s. The Federal Circuit has addressed the question of whether the sale of a patented product outside the U.S. exhausts the patent right, at least in 2 cases. And what they decided in the Jazz Photo and the Fuji case was that a U.S. patent can only be exhausted by a sale in the U.S. of the patented product. So this is an interesting question that has come up recently because last year the Supreme Court, or in 2013, the Supreme Court decided the Kurtzang case. This was a copyright case. And what they decided there was that the authorized sale of a copyrighted work anywhere in the world exhausts the U.S. copyright. Now the question has arisen again in the Federal Circuit. We have a case called the Lexmark case, and the Federal Circuit has decided to hear this case en banc. They've asked for special briefing and amicus briefs to be filed, and the oral argument in that case actually just took place in October. And the issue is whether or not they should reverse the Jazz Photo decision and recognize international patent exhaustion in view of Kurtzang. Whether or not this decision of the Supreme Court in a copyright case should carry over into the patent area and be treated similarly. So I think it's going to be a very interesting decision from the Federal Circuit, and we can be almost assured that whatever the decision is in the Lexmark case, it will be appealed to the Supreme Court. So the Supreme Court will be eventually required to decide whether or not the sale of a patented product anywhere in the world exhausts the U.S. patent right. I think that could significantly change the way licenses are granted in the future, whether or not someone is worried about international exhaustion. I know we have exhaustion in Europe, for example, in the European community. So I think you should stay tuned to see what happens in the Lexmark case. It will be probably decided sometime early next year. And then we'll probably have to wait longer for a Supreme Court decision on the Lexmark case. Thank you very much.
As I promised earlier, I'm going to say just a few words about these procedures, new procedures for attacking patents in the Patent and Trademark Office. And we're going to do this as a roundtable, so I'm going to make the presentation, but Dave and Alan will interject if they have something that they want to contribute. So the America Invents Act created a procedure for attacking patents in the Patent Office. You have 3 judges for each of those proceedings. There are 3 types of proceedings. There's an IPR, which is an inter-parties review. There's a PGR, which is a post-grant review. And there's a CBM, which is a covered business method case. The IPRs, the ones that apply to existing patents and patents that were granted under the old law, so before March of 2013, you can attack, but you can only use patents in printed publications. Then you have the PGRs that will be used to attack patents that were filed after March of 2013, And there, you'll be able to make almost any attack that you could make in district court, but you'll have to do it in the first 9 months after the patent issues. And then finally, you have this short-term procedure. It was for 7 years for covered business methods, and that's for patents that claim a method, apparatus, or operation used in the practice, administration, or management of a financial product or service, and those will only go for about 4 more years. The procedure takes about 1.5 years from the time the start to the end. The person who wants to attack the patent files a petition with evidence. The patent owner then has 3 months to file a preliminary response. Then the Patent Office decides whether to institute a proceeding, and if so, on what grounds they'll do that. And usually it's only 1 or 2 grounds among many that are contained in the petition. So petitions often will have 5, 10, or more reasons, and the Patent Office will only choose 1 or 2 to go forward. After it's instituted, the patent owner files a response and possibly an amendment of the claims, usually not. The petitioner files a reply, an oral hearing is held, and then the Patent Office issues a decision, and that decision can be appealed to the Federal Circuit, but the standard that the Federal Circuit looks at is whether there's substantial evidence to support the decision. Not whether it's right or not, simply whether it could be right. So and then of course rather than in district court when you have very expansive discovery, in the Patent Office you have very limited discovery. So the procedures are really biased in favor of the petitioner. In the first place, the petition, the patent owner cannot present any evidence of an expert in connection with their response. So it's a very limited response, and what that means is that many of the petitions are granted. Initially it was over 90%, it's still above 60%, and they're only instituted if the Patent Office has already decided that the claims are probably unpatentable. So now as the patentee, when you finally get to put your evidence in, you're working uphill. You're trying to explain to these judges why they're wrong. And then you also have the possibility with the reply that the petitioner files, they'll put in new evidence, and you have no right to do anything other than if there's an expert declaration to cross-examine, but you can't file a paper that goes along with that. So there are a few changes being considered. There is a consensus bill among various of the organizations in the US that they would like to have Congress pass, but because we're in a presidential election year, I'm sure none of you have noticed Donald Trump or any of the other turkeys who are running for office. But in a year such as that, you don't have this kind of action. So we're probably at least a couple of years before we're going to have these changes. But the changes would include things like amendments being handled by an examiner rather than the board, making the standard higher to invalidate a patent, allowing a patent owner to provide expert testimony with their initial submission before institution occurs. And that's a very quick outline of the procedures. And I'll ask Dave and Alan what their observations are in this regard.
Well, thanks, Danny. I know that as of now, there have been over 6,000 of these IPR cases filed in the Patent and Trademark Office. And I'm wondering how the Federal Circuit is going to be able to handle the appeals from those decisions in the future, because the Federal Circuit doesn't have any more judges than they have always had, and they've already got a pretty full docket. So my own feeling is that there's going to be an overwhelming number of appeals eventually getting to the Federal Circuit. I don't know how the rest of you feel about that, but.
I would agree with Dave on that topic, but I also wanted to raise the very important strategic value of these procedures. If you're a defendant and you're accused of infringement, It is not inexpensive to go into these things, but it's certainly much less expensive than having full-blown litigation. And there's a good likelihood that you wouldn't even have to proceed throughout the entire proceeding, because the patentee, seeing that his patent is likely to become invalid, would want to solve the problem by licensing you under very favorable terms. So this has brought the pendulum the other way, and really sort of anti-patent in a way, but certainly very favorable to those who are accused of infringement, and especially those who are accused by trolls or non-practicing entities of infringement.
Yeah, I think some time ago I predicted, or I gave the idea that perhaps our system over time will become more and more like the German system, where validity of patents is judged by the German patent court, and the regular courts determine infringement. And because of the provisions in the AIA that allow stays of pending litigation when there is an IPR filed, that's what's happening, I think. Many district courts now will stay the litigation and allow the IPR to go forward, perhaps hoping that the patent will be invalidated so the judge doesn't have to worry about the case.
So we need to wrap this up, but we can have a question or two? Yes? One question. All right. Does anyone have a question? Yes, Martin.
Thank you. David, you mentioned at the beginning of your presentation that today's James Pulley will talk before the Senate about the trade secret law. Could you give us a brief overview?
Yeah, as Alan mentioned, there's a pending legislation in the U.S. Congress to bring about a federal trade secret protection statute. In the United States, trade secret law is essentially state law. We don't have any federal overriding trade secret law in the United States. So this, if it passed, would be the first time that we would have an overall federal statute. And it establishes standards and other things for protecting trade secrets if it was successfully passed. I don't know what the likelihood of passage is at this point, but there's a lot of interest in the Congress, so perhaps it would be something they could vote on as a bipartisan bill.
Okay, so with that, I'd like to have you join me in thanking our speakers.